Michigan's Supreme Court has ruled Donald Trump can remain on the primary ballot. Multiple groups had pushed for his removal under the 14th Amendment, which bars someone from holding office if he is, quote, engaged in an insurrection.
What's the difference between the Michigan decision and the Colorado decision? And the big difference is that the Colorado Supreme Court got to the merits, meaning the substance. They got to the big legal question of what does the 14th Amendment prevent and what does it allow? In Michigan, the court did not. This is all about procedural grounds. In Michigan, there were two bases for the decision. The first one was this is a political question. Courts shouldn't be weighing in. So again, they didn't get to that federal constitutional question. The second was that the Secretary of State, at least on the primary election ballot, doesn't have the power to kick somebody off the ballot, doesn't have the power to determine eligibility. So this is a very different decision, not just in outcome, but in how you get to that outcome.
U.S. Attorney Brett Tolman worked on the Senate Judiciary Committee Council. He joins me now. Thank you so much for talking to us.
Thanks, Julie, for having me.
So the Michigan Court of Claims judge who first got this case said that state law doesn't give election officials any leeway to police the eligibility of presidential primary candidates. He also said that the case raised a political question that shouldn't be decided in the courts. Why wasn't this the case in Colorado?
Julie, Colorado is a different dynamic. The state actually does have a provision that requires that the state certify through the candidate that they are eligible to run. It's nuanced, but it still shouldn't have mattered because you're applying the Constitution, the 14th Amendment to the Constitution, and the reality is you don't even get to that question. I'm waiting for the Supreme Court to actually be the adult in the room, come in and say, hey, all of you that are clamoring and stretching the law in ways that it's not meant to be, here's what this provision means. It was articulated to prevent officers of the Civil War from running for office when they led the insurrection against the United States. I mean, that's plain and simple. It's never been applied in the manner that it is now. And it's a radical effort from the left to keep Donald Trump off the ballot box.
The Colorado Supreme Court's decision, as you know, to kick Trump off its primary ballot has been paused pending an appeal.
The Supreme Court could simply not decide whether to take the case or not. If they do that and they hold off and they wait to see what happens on this legal landscape, President Trump will still be on the ballot in Colorado. So the Supreme Court was very, very wishy-washy when it came to what they were actually doing. They indicated that while the Supreme Court decides, he remains on the ballot.
The point here is this, that there is still an ongoing trial. OK, and when you go to trial, typically, this is how this works in the legal system, the justice system, you get convicted. You are either found guilty or you're found not guilty. There has been no conviction. Therefore, he has not been found guilty. So it does beg the question why any state should have a say whether Trump is eligible to be a candidate based on a trial that has not ended.
I think, Julie, your analysis was more on the mark than any of the Supreme Courts so far that have decided the issue. It's very simple. Take a look at this and say to yourself, do you have a candidate that we have a finding of insurrection? We don't even have a charge of insurrection yet. He has multiple criminal cases against him. None of them touch the issue of insurrection. And I think you nailed it, Julie. This is where we're at in this country. It's a political, machinery that's been put into place to just prevent one candidate.
Donald John Trump, President of the United States, is not guilty as charged in the first article of impeachment. Donald John Trump, President of the United States, is not guilty as charged in the second article of impeachment.